Egan, Berger Weiner LLC is an independent financial services firm which is experienced in all aspects of investment and retirement planning. Today, they're here to give us some advice on IRAs, Roth IRAs, and the retirement fund exemption. Bryan Beatty, a certified financial planner and partner at Egan, Berger Weiner LLC, is here to break it all down for us and make it understandable. So We're talking about the Supreme Court and bankruptcy and IRAs. These things all fit together. Tell us why it's top of the mind right now.
Sure. So about a month ago, I'm not exactly sure the date, there was a court case that was held up in bankruptcy law that basically came out on the side that inherited IRAs may not actually be considered creditor protected from bankruptcy, which was a case which I think would set precedents in the way retirement assets are handled in the future.
Well, it's something that we should be considering when we're talking about our long-term planning and how and who we're giving our funds to after we pass, right? So what does this exactly mean? So I'm getting money from an inheritance, an inherited IRA. Is that what we're talking about? It's in somebody else's name? And what happens from there?
Well, usually, if you're married, you would name your spouse your IRA beneficiary.
Okay.
And traditionally, the spouse would then turn around and just make that IRA their own IRA.
Okay.
Not in every situation. Sometimes there are reasons in which you would actually keep it as an inherited IRA, such as early withdrawals if there's a difference in age between spouses. But by and large, you go through the extra step of making it your own IRA. And you want to make sure you do go through the extra step of making it your own IRA, especially because of this court case. But what it really speaks to are non-spousal inheritances, like your children, or grandchildren. And the reason is that the court basically stated that because the funds did not originate from the contributions made by the individual who inherited the IRA, it wasn't deemed to be a retirement plan for the purposes of creditor protection.
So does that change now how we should be doing things? You just explained how it sort of has always been done.
Sure.
Is this something we should take into account and change how we handle?
I think it could be. And in fact, a lot of times when we talk to clients and when we see clients, they've basically named their estate or their trust the beneficiary of the IRA. And you have to be very careful to make general provisions of a trust as a beneficiary to an IRA. In many cases, there'll be a gift that might go to, say, Uncle Charlie or Nephew Alan, or maybe to a charity, and it doesn't actually address what assets might go. You know, send $50,000 to person A, B, C. And when you make a general statement like that, it doesn't differentiate between retirement plans and regular assets. So you have to be very careful to include what's called look-through or see-through provision or languages inside your trust before you go ahead and name a trust a beneficiary. I would seek counsel before I would do that.
This is not something for like just me
to
handle.
No, definitely not. You want to seek professional advice.
So talk about when we're dealing with non-spousal IRA beneficiaries. Does that change, or is that what you were just talking about?
Yeah, that's exactly what I'm speaking.
Charities? Okay.
I mean, in some cases, a spousal should also do it. Not normally necessary, but definitely in a non-spousal situation, if you're worried about creditor protection, and you should be, because you don't know what will happen in a future generation. You want to make sure this asset that you worked really hard to actually save would be preserved against such a situation. Then you want to really look at possibly using trust and trust language.
And general trust beneficiaries, how does that work?
Well, as I was talking about before, you want to make sure that you have special language. You don't want to have a general trust.
Go to the specialists always.
Absolutely.
To help you with all
you
these
definitely
things.
Want to go to a specialist in this case.
And what are those specialists? It's like you guys at Egan, Berger,
An estate planning attorney in this case. You might want to consult your CPA, and if you don't have a financial planner and you need to get a plan, this is part of a general financial planning strategy that might be applied for asset preservation.
And IRAs and Roth IRAs are things that we should still be putting our money into? Are they pretty safe still?
Sure, absolutely. Well, safe is a relative question. It depends what you invest in. But the reason you would have an IRA is because you need to have money set aside for for retirement. And you want to make sure that you're saving enough. An IRA being an individual retirement account, Roth IRA being a after-tax, tax-free retirement account.
Okay.
And they are different, so you want to make sure that you understand the differences before you make an investment.
Anything else we should be aware of this summer? Anything changing that we should be thinking about, or this is what we should be looking into?
Well, what I would say is if you have not had a plan developed for yourself, that this summer before school begins, you get one and you develop one for yourself.
Excellent. Thank you so much, Bryan Beatty of Egan, Berger Weiner LLC. Makes it all sound so normal. More Let's Talk Live's coming up. Stick with us right here.